Hello students, here we will study the second chapter, detail of various essential element of law of contract. Under this chapter and then the index, we will study 2 points basically. First, what is the meaning of essential elements, and secondly, we will study in depth the detailed discussion of all elements. These are the list of essential points of law of contract. First is you require an agreement, then you require at least two parties. Enforceability by law is an essential purpose, proposal, acceptance, intention to make legal relationship, free consent, contractual capacity, consideration, lawful objectives, and finally the 11th point is possibility of the performance. These are essential 11 elements which you always require to do an agreement which will convert into contract in case of Indian law of contract 1872. So first we need to understand what is actually the meaning of essential element. As you all know that contract is basically a legal agreement. An agreement means like when a person has given a proposal and same proposal has been accepted in the presence of some consideration known as agreement basically. If suppose that agreement is carrying the legal objectivity or legal consideration, then it will convert into contract. Even I told earlier that contract is basically the base of the business law or commercial law. Even this is very important significant term of our daily routine life. We used to have a lot of deals every day in our life, and there we are actually making some transaction. And transaction, if you want to regulate that, then you require some law portion for that. And that legal portion actually known here law of contract. So in ordinary words, if suppose you are making some deal with some other people and you want to bind that deed, then definitely you require some help from judicial person, and that help only possible when some law is available. And India, that law is known here as Indian law of contract, which came into force on 1872, 1st September. So they said that for a contract we require some essential points. If one point is not present in that particular list, that contract will not actually enforce. That will be only and only says an agreement. So now you need to understand that these 11 points are actually a category which are essentially you require to establish a contract under Indian law of contract. Now we will study 1.1 particular from this all list. First is you require an agreement. What is an agreement? First you need to understand. Agreement basically is known as promise also. Promise means where one person is showing his willingness or expressing his opinion in front of the next person, and next person is actually ready to follow that acceptance. Next person is ready to follow that instructions known as actually promise. So in simple meaning, agreement means a promise. It is created when a person makes an offer to another person and that other person accepts it, known as a promise or agreement. Even every promise and every set of promises forming consideration for each the party of an agreement. So agreement basically is a combination of three important technical terms. One is offer, one is acceptance, and one is the consideration. Offer means suppose X is saying to Y particular to do something. This is actually the willingness of X where he is showing his opinion. And if suppose Y is giving his consent particular for the same proposal which has been made by the X to him, known as acceptance. And thirdly, if both the parties are mutually getting something from each other, known as acceptance. So these 3 points are actually you always require if to do an agreement. So proposal means offer, acceptance means consent, and consideration means mutual benefits. So if you are carrying these all points, then it will be an agreement, or agreement basically is a promise. Next essential point which you require for Indian law of contract is at least two parties. As I said earlier that contract is basically a legal binding between two parties who have made some transaction, and that transaction actually known as agreement. So always for a transaction, for an agreement, you require two parties. In any contract, first we require the format of an agreement, and it is always created by at least two parties. It is possible more than two parties are, but at least minimum you require two parties. One will be the party who will known as proposer, because he will give a proposal to the another party, and the another party to whom proposal was made he will known as the offeree. So two parties are minimum you required. Therefore, we used to say that one person can't do a contract, because there is always an essential requirement, first proposal to another person, and then that proposal will be accepted by another person. Therefore, minimum two parties you are always required, and first party known as proposer and second party known as actually offeree. And when this proposal will accepted, then the proposer will convert it to actually promiser, and the offeree will convert to the acceptor. Therefore, this is true and fact statement that no single person can make an agreement, and if agreement is not possible, then law of contract will never exist. This is very true point, that because contract is an extension of agreement only. So primarily you actually require an agreement, and for agreement you require proposal, acceptance and consideration. So first proposal will make by a person, and then parallelly it will accept by the second party. So therefore you require at least two parties here. Third point as an essential element is enforceability of the agreement. Every agreement is not law of contract. Only those agreements which can be enforced by law will be deemed as law of contract. Therefore we used to have that all contracts are agreement, but all agreements are not contract. We know that if you need to make a contract, first you require an agreement, but it doesn't mean that all agreement will be contract. Remember here, only those agreement will be contract which will be converted, which will be enforced by the law. So what is the measurement or parameter for enforceability? An agreement which is enforceable by law, then it creates some legal relations and obligations between the parties. Always remember, this is also an essential element, create legal relationship. If two parties are making an agreement, it means they are having an intention to do the legal binding. If they are doing legal binding, it means some obligations and rights will come on both the parties. So due to that legal binding and rules particular, enforceability will come in the picture, and then it will be a contract. Otherwise it will remain only and only as an agreement. It will be never a contract. So enforceability of the agreement depends on the intention first of the party, and secondly it depends on the legal objectives as well as the legal consideration. So remember here, only those agreement will be contract who will have an intention to do the legal binding, who will have legal objectives, who will have legal considerations. Next one is proposal. As I said, proposal is internal part of an agreement, as well as you can just understand it as an essential part of the contract. The term proposal is almost similar to the term offer. The term proposal is the base of an agreement. If you need to do an agreement, essentially first you require to make a proposal to the other party from whom you will want their acceptance. A proposal or offer is an expression of willingness by one person to another particular for his entry into an agreement on particular that terms which are stated by him in the proposal. For this we will just take this example. If suppose A has given an advertisement particular for sale his land and the newspaper, and he's saying that he will take 10 lakh rupees by demand draft. So this is what his condition he's putting. 10 lakh rupees will be consideration. A is giving an example, A is giving a proposal, he's showing his willingness, he's expressing his ideas. If suppose anyone will just buy his property on the stated condition, then it will be an acceptance of the proposal. So proposal means when one person is showing his willingness on behalf of some certain conditions. Again, we will make continued discussion for it. The person who's making the proposal basically known here as proposer, and to whom he is making proposal known here as offeree. As I said earlier, basically you require always two parties minimum. One is that who's making proposal, to whom we recognize here as proposer, and to whom actually it was made, he is known here offeree. Although when this proposal will accept it, proposer status will just get converted into the promiser, and offeree will get known here as the acceptor. Suppose again Ram has given a proposal to Sham and Sham has accepted it. So earlier Ram was proposer, now he is a promiser, and earlier Sham was actually offeree, now he is the acceptor. Again, few more points for proposal. If any proposal you are just going to just propose it, you always require two parties, because one will be that who will give the proposal, parallelly second will that to whom it will be given. Second one is a proposal may be positive, either may be negative. It may be positive means if suppose you are giving a proposal to do something, this is known as proposal positive. If you are giving a proposal not to do something or abstain to do something, this is known as the negative proposal. Third point is that proposal must be made to obtain or to get the consent of the party to whom it is actually given. This is very essential point, that it doesn't mean that you are only giving proposal to make the system only. You're giving the proposal to get his consent positively. Proposal must be made with an intention to create legal relations. If one party giving the proposal to another party, it simply says that the first party is having an intention to make the legal binding between them particular. If they are not having the legal intention to make the binding, then it will be never a proposal under Indian law of contract. Next is, it must be communicated or it must be signified. Means it should be always just expressed to the party to whom it is actually giving. If suppose this is not in the mind of the party to whom it is actually given, then there will be no value of the proposal. If A is giving a proposal to B, then it is actually essentially A requires to just let him know that he is giving a proposal. If B is not able to understand what has been given to him, then it will be no value of the proposal by A. So it must be even communicated. Proposal may be expressed or either it may be particular implied. You can use any kind of medium just to give the proposal. It can be sometime expressed proposal, sometime it can be implied proposal as well. Expressed means when you're putting your ideas very clearly by the words, then it is known as expressed. It may be verbal words, it may be written words. But implied means which is actually not in the format of expression, clear expression, which is actually likely to be deemed that this is a proposal. For example, if suppose there is a market where the second-hand auto cars are just going to sale. If one person has actually given his car for that market, it simply says that is implied proposal that he has shifted his car in that market to sale, to buy from the next party only. So this is actually the implied proposal. And express proposal is that if same person has given an advertisement in the newspaper to sell his car, that is actually expressed proposal. Next is proposal, either offer may be definite only. It must be definite even. It should not be indefinite. It should be always clear as well as. Terms and condition of the proposal must be communicated. This is, remember always that proposal must be definite. It should not be indefinite. If suppose you are just willing to sell your car, then it should be clear which model of car you are carrying and when actually you purchase, what kind of price actually you want to get it. Every condition should be definite, and these all conditions should be communicated well to the party to whom you are giving the proposal. Next is, Proposal should not bind the other party for replying. We require an intention to get his consent. This is also an essential point. But it doesn't mean that always the next party is binding to give the consent. You require to get his consent, but it doesn't mean that he is actually legally restricted from you that to give the consent only. He should be always free to give his consent. A tender may be an offer or a standing offer. This is also next point for that. A tender means suppose one party is giving a proposal to all the party to construct something or to make something or to build something. That is a tender. He is just calling particular the bid prices from another. So then tender may be also deemed as an offer or standing offer. Standing offer because when the parties will give their bid prices, then accordingly the lowest bid price or favorable bid price will be just selected by the party, then therefore it will be a standing offer. When an offer is accepted on the basis of some other terms or conditions by the next party, then it will be a kind of a counter offer. Suppose Ram has given a proposal to Shyam on some conditions, but Shyam is accepting the proposal on some other different condition, then it will be never a acceptance. It will be particular counter offer because Shyam has accepted it on the different conditions, not on behalf of the certain condition which has been earlier stated. When two people make similar offer to both of them without having the knowledge that they are also getting the same, then it will be particular cross offer. So counter offer was different where actually a proposal was accepted on different conditions. But in case of cross offer, both the parties are giving the same kind of offer on same conditions to each other because they actually didn't know that they are getting the same from the each party. So this is known here as cross offer. Such offer do not actually make a legal relationship because they are not having the intention to get it. Few more points regarding proposal. Proposal may be either specific, either general. Specific stands like if you are giving a proposal to only an individual, a specific individual, and you require the acceptance from him only. But general proposal you are just giving to the public at large. So you can get an acceptance from anyone else. If suppose Ram is giving a proposal to Shyam only, it will come under the category of specific. But Ram has given an advertisement in the newspaper, it is known here as the general proposal. Now, the next fifth point, as I said earlier, that there are 11 points to understand the essential elements. So, 4 we had covered now. This is the fifth point, acceptance. Acceptance meaning is the consent of the party to whom proposal was made, who was earlier known as the offeree. So, it is a communication of his intention to be bound by the terms of the proposal. Suppose again Ram has given an example, Ram has given an offer, a proposal to Shyam, and Shyam is now just ready to follow all the conditions which has been stated in the proposal by Ram. This is known as acceptance of the Shyam. When one person to whom the proposal is made signifies his consent thereto, then the proposal is said to be accepted always. A proposal when accepted becomes a promise and or agreement. Moreover, if the agreement is enforceable by law, then it gives rise to just certain legal effects to the parties. This is actually the legal meaning of acceptance. Proposal means you are showing your willingness, and acceptance means you are ready to follow that willingness. So when the proposal has been accepted, it will known as agreement. If suppose that agreement will be legal agreement, then it will be a contract. So we can prove our lines that all contracts are agreement because that they will earlier accepted, they was earlier accepted by the acceptance, and because earlier it was in the format of proposal. So now the point is that who may actually accept? Only the person to whom the proposal or offer was made, he is only liable to accept the proposal. No one else can do that. As I told earlier that there are two types of proposal, one is general and specific. In case of general proposal, only the all party from anyone that who had actually received it, they are entitled to give it. But in case of specific proposal, to whom it was actually paid, he is only entitled to accept it. Few points are here. For essential of acceptance, acceptance must be absolute or unqualified. It means if suppose you are accepting the proposal in same way, this is known as acceptance. Earlier it will be a cross offer. Secondly, acceptance must be in the prescribed manner which was clearly expressed in the proposal. If it was told by the proposer to accept it in the same way, then the offeree has to follow the same instruction. Otherwise, it will not deemed as an acceptance. Acceptance may be given by performance of the condition as well. If suppose A has given a proposal to B that he will sell his car for 10 lakh rupees and B is just submitting rupees 1 lakh as the advance payment, it means he is actually following the conditions of the proposal. Acceptance may be expressed or implied. This is also a very important point, that acceptance may be just given in the written format or by the verbal words, and it can deemed as well as implied also. It must be given with some specific time or reasonable time. If suppose it was told by the proposer that acceptance should be given in 2 days only, then in only 2 days offeree has to give that. If suppose he is not, there was no specific time period has been given in the proposal, then you can take the reasonable time, but reasonability should be not unreasonable. It must be given while when the offer is actually in force. If suppose A told to B that he needs his consent in next 2 days, if suppose B is giving the consent after 2 days, it will be not deemed as an acceptance, because after 2 days the offer will not in force. And acceptance must be always communicated, as we discussed earlier in proposal, that it should be in the knowledge of that party to whom it is actually given. Same thing we will follow over here in case of acceptance. Acceptance should always be in the knowledge of that person from which actually proposal was received. It must be given by the person to whom the offer is made. There are two types of actually proposal, general and specific. In case of specific only, it should be always just given by that party to whom proposal was made. Few more points. Acceptance must be from a competent person. It should not be from incompetent person. There are some criteria essentially you require to understand the competency. A person should be major, he should be more than 18 years age. It should not be disqualified by any other law. It should be always sound person. So thing is that if he is incompetent, it simply says that law assume that he is not able to understand the condition of a proposal. So you require an acceptance always from a competent party. It must be communicated to the offerer himself. Rejected offer cannot be accepted. This is also a very important point. If any time a proposal has been rejected, so in future that cannot be accepted. If suppose A has given a proposal to B just on 10th January, but on 10th January it was rejected by B, so it doesn't mean that in future again B will accept the same proposal. Next point is silence does not generally known as acceptance. If B is not saying anything in particular for his acceptance, he is purely silent, it doesn't mean that silence will just get it deemed as acceptance. In case of some circumstances of acceptance, must show that the acceptor is able or willing to fulfill the term of offer as well as. Generally, if suppose you are giving your acceptance, it assumes that you are ready to follow the conditions. But there are some other cases also where you need to follow some term condition as well as to understand that you are ready to follow the proposal exactly. Now, the next point, sixth number, is intention to create the legal relationship. As I said earlier that contract is an extension of an agreement. If suppose you have done an agreement, that agreement is making the enforceability function, then it will be a contract only. The question is that how an agreement will be enforceable. First, it requires always the intention to make a legal relation. The agreement which do not create legal bounding between the parties never will enforce by the law. So always you essentially require an intention between the parties to create the legal relation. There are a large number of social, domestic, political agreement which do not create legal relation because the parties to the agreement do not intend to create the legal relation. Therefore, they are never become a contract. If suppose your neighbor has actually invited you to come on the marriage of his son, he has given a proposal to you, but it doesn't mean that if suppose you will not go over there, then it will be kind of a legal relationship, it will kind of legal binding on you. Some social, some domestic, some political even, they that kind of an agreement always do not require, do not intend to make a legal relationship. In that case, they will be never become a contract. So remember that if you require any business contract, you require always an intention to make the legal relation, because you know that contract creates some legal obligation and right on both the parties, and it means that they have to follow that rules. If they are not following the rules, definitely action can be taken against the defaulters. Even these type of agreement, the usual presumption is that the parties do not intend to create a legal relationship. However, in business argument usually presume that the parties intend to create the legal relation. Therefore, I said earlier that business law basically based on the law of contract. If we do any kind of transaction, if we purchase anything, if we sell anything, definitely for the satisfaction we always wants to make ourselves secure, and that security we can just get it through legal binding only. So in case of all business arguments, we actually assume that both the parties are having an intention to just convert it into the legal binding. Next is the contractual capacity. Only legal competent person can make a valid agreement. This is also very important, as you know that agreement is a combination of proposal, acceptance and communication. But parallelly, the parties who are making the agreement, they should be always competent. If they are not the competent, that deal will be always void. It will be never a valid deal. So what is the criteria to understand that who are actually the competent party? Basically, there are 3 points to understand it. First, both the parties should be major. Means according to Indian Majority Act, they should be always above than the 18 years age. Second is, the person should be of sound mind. Means he should be always capable to understand the effects of the agreement on him. If suppose he is not able to understand the effects rationally, it means he is actually not of sound mind, he is unsound mind. And third is that the person should not be disqualified from any other law to make a contract. If suppose he has received sometime an imprisonment or some any other legal penalties on him, then definitely it will be a barrier on him. So three category always you require to do to receive the contractual capacity, or known as competent party. First, both the parties should be above than 18 years age. Secondly, they should be always capable to understand the legal effects. And third is that they should not be disqualified by any other law to make a deal. Next, we will study the point is free consent. Consent we have already studied earlier. Consent was that where the party to whom proposal was made, he actually pointed out his expression to follow the conditions. But that consent should always also require free. It should not be restricted from following points. It should not be related to coercion. It should not be related to undue influence, fraud, mispresentation or mistake. If suppose your consent is said, if your consent is related to any one of these items, then it will be not known as the free consent. And this deal will be definitely voidable deal. This will be never a valid deal. It will be never enforced straight away by the law. So it will be never a contract. It will be only and only an agreement only. So now try to understand what is the meaning of coercion. If you have taken the consent of the another party by some physical pressure or some threats to him, then it will just not known as the free coercion. Undue influences says when both the parties, when in the deal one party is actually having the right to influence the next party according to his opinion, this is known as undue influences. Third is that if one person has just made some intentional mistake against the next person to get his consent, known as fraud. And next one is that when one person has made a mistake by chance, not with an intention, known here as mispresentation. And finally, if you have just done some correct points regarding the from law, it is known here as mistake. If you actually not able to understand the law in depth earlier and you have done a mistake and you have taken the consent mistakenly from the another party, known here not as free consent. So for free consent, always you require the consent without physical threat, without undue influences, without intentional mistake known here as fraud, without mispresentation, and without any mistake of the law. Next is consideration. Consideration is actually an essential part of the agreement. And consideration basically says the mutual benefits for both the parties. As you know that you require minimum two party. So what all the parties are getting in receiving of their promises from each others, that is known here as consideration. For a simple example, if A is actually selling his car for rupees 1 lakh to B and B is buying his car, it simply means that A is receiving rupees 1 lakh as consideration and B is receiving here car as a consideration. So consideration means something in return. In other words, consideration means something which the both parties receive in return for their promises. Now few points for consideration. It must be lawful and real. It should be always realistic. It should be always legal. It should not be illegal. If it is illegal or unrealistic, it will be never deemed as consideration. And finally, it will be only an agreement. It will never convert into the contract. It must have some values in terms of monetary benefits. Consideration means if you are just doing something, you are getting some benefits, it should have some values. It should be able to just calculate it in the value in the monetary benefits. It must be adequate or fit according to the situation of the contract. It should not be inadequate. It should be always adequate. Consideration must be at the desire of the parties. And finally, it must be for past, for present, and for future as well as. So essentially, you require these points to understand the meaning of consideration as well as for legal contract. Next is lawful objectivity. An agreement will be unlawful if any of the following circumstances will happen. I'll always remember, if your agreement is carrying illegal objective or illegal consideration, it will be never enforced by law and therefore it will be only deemed as an agreement. So therefore we used to say that all contracts are agreement but all agreements are not contract. Suppose some agreements are carrying unlawful objective, they will be only an agreement, they will never convert by law. So what are those points who are having a measurement to understand that what is unlawful or lawful? First is, if the court regards it as immoral, if you are having some objectives or consideration which are not carrying the morality, which are purely immoral, known as unlawful objectives. Secondly, if you are doing something against the public policy, known here as unlawful purpose. Third, if your purpose is just to give an injury to physical injury or some actually financial injury to the next person, known here as unlawful objective. And fourth is that if you are making intentional mistake, known here as fraud. And finally, if it is of such a nature that is suppose it will permit, then it would defeat the provision of any other parallel laws. So these are 5 elements to understand what will be lawful or unlawful. So basic criteria is that morality, public policies against, third is fraud, fourth is particularly suppose you are giving some physical threat or injury, and fifth is that if suppose it will allow, then it will just actually defeat any other provisions. So these are some points which you always require to carry with you if you want to convert your agreement into the legal contract. Next is the last point of essential element is possibility of the performance. An agreement will be only valid contract when it is possible to be performed as well as. If you are making that kind of agreement which is not actually possible to just perform it, that will be never a contract. And here actually you require the performance as well as physically or legally. If suppose you are able to physically perform it, but it will never applicable in front of law due to some unlawful objectives or unlawful consideration, it will be never deemed as performance. An agreement to do an impossible act, known here as void, it will be never a valid. If you have done that kind of agreement which is never possible either to perform physically, either to perform legally, then it will be a void deal. It will be never a valid deal. It will remain as an agreement only. It will never convert to the contract. There are 2 types of agreement. One who was actually at the time of creation possible, but after it onwards actually it is now impossible. So this will non just performance based deal from the starting, but onwards it will be now impossible. But if there is a deal who was actually from the beginning impossible to perform it, then it will be actually void from the stage 1. So this is the meaning of possibility, means you require to just perform it physically as well as legally. So this is, we actually discussed up to 11th point, the essential elements which you always require to follow one by one, and these essential elements all require to make a contract. And therefore we used to say, if you are having these elements in the agreement, then agreement will convert into contract, otherwise it will remain only and only as an agreement. Thank you so much.